Welcome, everybody, to another episode of Legal Tech Week, the show where we talk about the top stories of the week out of legal tech and innovation. I am Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. And some interesting stuff to talk about today with our panelists here. And joining us today are some of our usual. So why don't we go around and do introductions? Nikki, you want to kick us off since you appear to be not paying attention?
I'm mad at corporate greed right now. My name is Nikki Black. I'm
Just
principal.
now?
That's unusual for the hour.
I'm the principal legal insight strategist at Affinipay, parent company of my case, LawPay, DocketWise, and CasePeer. I write legal tech columns for Above the Law, ABA Journal, and the Daily Record, and also oversee some industry reports that we put out and author them. And right now I'm mad at Pearl Vision on behalf of my daughter. So that's what I'm mad about right now.
All right. Joe Patrice.
Joe Patrice from Above the Law and Thinking Like a Lawyer. I am, it's kind of a dreary day. I was not chosen as Pope the other day, so I had, I had my hopes, but it didn't work out for me. But
You would
it
not
it
want
is.
that job, would you?
I mean, I don't know. It could be fun. Now we are going to have somebody from Chicago, as I quickly pointed out, and I guess a lot of people made this joke, but the deep dish Eucharist that we're going to start having to deal with now is and Malort. Uh, anyway, yeah. So
All right.
that's what happened with me.
All right. And speaking of Chicago, Victor.
Hi everyone, Victor Lee from the ABA Journal. It's been crazy here. Like people are going nuts about the Pope being from Chicago. All the newscasts led with it yesterday. People are really excited about it. I saw the memes with him coming out to the Chicago Bulls entrance theme, which was kind of funny.
Yeah.
I hope he doesn't take things personally like Michael Jordan does. But hopefully he'll be a little bit less competitive and less crazy. It's also funny on my social media because I have a lot of Filipino friends, so like they're all outraged that their guy didn't
Uh,
win. But then a lot of my Chicago friends are really thrilled that their person won. I was like, I didn't know this was a that you guys have a personal stake in this, but there you go.
Yeah. Oh, well. And Steve.
Hey, Steve Embry here. I'll write the blog Tech Law Crossroads, and also from time to time I write for Above the Law and Kentucky Bench and Bar magazine. And I'm freshly back from the CLOC conference that I graciously was able to cover for Above the Law.
So I actually thought we'd start with clock, but I thought Stephanie was joining us, who was also there, and I don't see her yet. I don't know whether we should wait a little bit and see if she shows up and can share her thoughts as well. Why don't we do it? Why don't we start with something else and
yeah.
see if she
That's good.
shows up? Maybe she's like stuck in traffic or something. I don't know.
Yeah.
So I think the probably the most outrageous story of the week, Joe, was yours. So
I mean, right?
not that you made it so. It was outrageous of its own, but you only helped. But
Yeah. Yeah.
you
No,
want to talk about it?
absolutely. So who flagged this for us? Was it you, Nikki? Somebody flagged this story for me. Yeah. It is in Arizona. There was a road rage incident several years ago, and tragically that resulted in someone shooting and killing someone else. And at the trial, trial happens, manslaughter, guilty. In the sentencing phase, and I want to clarify, I feel I have to clarify the phase that we're in because I think it does play into the conversation. In the sentencing phase, in the place where victim impact statements would normally be, the victim decided to talk, or more or less didn't decide to talk, but the victim was nonetheless invited to talk, and the victim on video shared some thoughts. This was an AI deep fake of the dead victim. It was scripted by the victim's sister who was trying to channel what she thought he would say in the circumstances, which I will say I would be fascinated to hear a psychologist talk about whether or not as a therapy mechanism or even as a way of getting better justice that might actually be useful. It's long been a fraught process to have victims talking at sentencings because emotions are as high as they are, and maybe by changing their point of view from themselves to trying to see it as their loved one did might have some psychological benefit, but that's above the pay grade of this podcast. Let's talk about the idea that we're doing deepfake seances for sentencing, because that doesn't seem like a great idea to me. I don't understand how I don't understand how the defense lawyer didn't try to put a stop to this. Maybe they did. The record isn't particularly clear on that front. But
They didn't. The article I read said they did not object.
they said they really didn't. Yeah, I couldn't tell whether they did or didn't, and just the judge overruled it. I would say this feels very much in the world of, as a judge, I would kind of sua sponte say, let's not go down this road. I understand that it's, of things I mentioned in my piece, it is sentencing. It is being heard by the judge. So there's not going to be a lot of the prejudicial impact that it would be if this were in front of a jury on the merits. That said, come on. Judges are not entirely immune to this, immune to prejudice. The judge, in fact, sentenced the guy to a year longer than the prosecutors were asking for, and it's not because prosecutors are known for being very lenient. That seems bad to me. It seems as though we're opening the door to this. This seems like I called it the ultimate hearsay hypo. This is an out-of-court statement that was never actually, it was out of the mortal coil statement that should not be admitted. Real problematic all the way around. But what else do people have? What other jokes do people have about this?
Should I play the clip? I've got it queued up here.
Oh, really?
Yeah.
Then go for it.
Let's do it.
I don't know if I've seen the clip.
You've seen it?
I don't think I have. No.
Wait a minute, here it goes. I think it goes.
To Gabriel Horcasitas, the man who shot me. It is a shame we encountered each other that day in those circumstances. In another life, we probably could have been friends. I believe in forgiveness and in God who forgives. I always have, and I still do. To my family and everyone that I've met along the way, it was a lot of fun. I always had a lot of fun. Love each other because you never know how long you have. But make the most of each day and live your life. It is okay to stumble. God has you. Remember, getting old is a gift that not everybody has. So embrace it and stop worrying about those wrinkles. Well, I'm going to go fishing now. Love you all. See you on the other side.
Hold on, the judge is here too. Get the judges.
I love that AI. Thank you for that. I feel that was genuine, that his obvious forgiveness of Mr. Horcasitas reflects the character I heard about today. But it also says something about the family. Because you told me how angry you were, and you demanded the maximum sentence. And even though that's what you wanted, you allowed Chris to speak from his heart as you saw it. I didn't hear him asking for the maximum sentence.
To me, that's the most bizarre. Well, it's all bizarre.
Yeah.
But the judge's comment is almost like the judge is like thinking this is really him. Whoops.
Yeah. It really was. There was a little bit where he did kind of admit that as you saw it, which gets to that kind of psychological experiment, thought experiment. But this is just not open mic night. This is not where we should be doing this. And I thought it was wild that a judge would not only not intervene, but would seemingly applaud it as though it was genuine. And then after hearing all this, impose a harsher sentence anyway, which seems to run counter to a lot of the spirit of what we just heard.
I also, where do you draw the line? This is bad enough, but do you bring on their potential children and grandchildren to talk about how much
Yeah.
they would have loved to meet their dad and grandpa, and now they'll never be born? Like, where does this end? Like,
Well, in fairness, some of that garbage does happen now. There is, especially in trials that last a long time, there are, 4-year-olds giving impact statements about how I don't remember my. So the emotional,
well, I'm talking about unborn,
yeah.
never conceived.
Oh,
Like,
I understand what you're talking about. I'm just saying, like that kind of a poll is already kind of the sentencing process is problematic in a lot of ways. Mark makes a point in the chat over here that I think is useful, that here there's a little bit of leniency perhaps the judge might have given, to the extent that this was an impact statement that seemed to be asking for more leniency. But there's no hard cap on that. There's no reason why you can't create an AI that bitterly talks about how awful it was to have died, scripted by somebody who didn't, and have that be part of it. That's even worse.
Yeah, well, one of the comments in the Washington Post report, where I just got the video off of, one of the guys in the comments said, "What if the sister had the AI image saying something like, 'This guy should fry in the electric chair, motherfuckers'?" It's like, who knows?
or what if it talked about how
Well, think of all the trials that this could have been used for. Like have an image of Nicole Brown Simpson being like, "Oh, I really wish OJ hadn't,
Yeah.
Right.
flashed me that night in front of my house while Ron Goldman was there with me." What's a more current, what's a more relevant one that's going through the Menendez brothers, right? Like, what if they had like Kitty and Jose being like, "Oh, our sons were so bad and they shot us because they wanted our money and blah blah blah." It's just, yeah, where do you draw the line with this? And I just can't believe the judge thought that this was such a good idea. I mean, like, he seemed so nonchalant about it, like, "Oh yeah, of course, let's see this." And I mean, yeah, it's the whole thing just doesn't seem right. But no.
I'm not surprised about the judge though, because I have judges that I've appeared before that just did not like the defendants. Like, no one likes, like they had such animosity towards the people that appeared before them, towards the bad guys. Like, everyone just was presumed guilty, even though that wasn't how they were ruling necessarily. Although they sometimes did things that they could get away with because they knew you didn't understand enough when you were a young PD. So I can imagine certain judges that I've appeared in front of being perfectly fine with that because they think that this victim deserves their day in court and they never got it. And so I think he must be one of those types of judges. But the whole situation is just pretty appalling, and it's just the idea that AI is showing up in the court systems in such inappropriate ways, and in a very Black Mirror ways, and it's just going to get worse.
I'm
Well, I mean, Black Mirror
without any real consideration, and sort of the thing that's worrisome is sort of the acceptance of stuff like this as ordinary. Okay, no, and I mean, and this was a sort of an extreme situation, but there's lots of lesser situations where audio statements in domestic dispute matters are played, and they may be fake, but the prevailing assumption is, well, they're not fake. That's fine. I'm going to listen to that. Yes, I mean, it's just a difficult situation that the courts are going to be facing. That worries me a lot.
It's interesting you mentioned Black Mirror there, because that was basically the first sentence of my story. It really did have that feel of rejected Black Mirror plot. Rejected as it was too ridiculous for a show like that.
Yeah,
Maybe the defense, maybe the litigators
case, which is the story that's like all over the Boston airwaves right now. Like now they can have the cop that she supposedly killed, like lying in the snowbank, talking about how cold it is here and how she wishes she hadn't run over him or something. I don't know.
Well, and maybe the litigators can explain this.
Like other people
maybe the litigators can explain this to me, but like, why wouldn't you object to this as a defense attorney? Because don't you then lose the ability to bring it up on appeal then, or isn't there some kind of rule that says that you can't? I mean, this would be like a pretty easy thing to just appeal, right? I mean,
it sounds like malpractice to me. I mean, as a defense attorney, you raise objections as long as they're grounded in a valid objection, whenever you possibly can, because otherwise you haven't. There's no foundation for the appeal. You haven't preserved the issue.
haven't
So,
preserved the issue. That's exactly right.
so,
That is kind of amazing.
so I've thought about this. Now, I do wonder if, presumably, before this got to the court, it was shown to the defense before they, to give them an opportunity to object. And I wonder if they made the calculated decision that having the victim say forgiveness was probably better for them than having the family get up there and cry the whole time. And that might well be. It may well.
Yeah.
It seems as though it backfired, but that might have been the answer.
But didn't the judge give the guy the maximum sentence anyway? So
More than the prosecutors asked.
yeah,
So, but Joe, here's in the Washington Post story says no one objected when Wales played the video in court. Blah blah blah. And Wales kept the video a surprise. She did not disclose it to the judge or to the defendant's attorneys. Arizona law does not require that.
Well, and then someone posted
still should have
a quote.
objected. The only thing I can figure possibly is if the defense was like, well, not going to phase the judge one way or the other, so why make a spectacle about it?
That's what somebody said in the chat, that probably it wouldn't have made a difference. But that's the case when you're a defense attorney. It never makes a difference with most of these judges, but you still got to preserve it for appeal, even if
Good
you know
point,
you're going to lose the argument. And so that
Yeah.
to me is, you don't just go, it's not worth it. And don't object ever through the whole trial because you know your client's going to lose. I mean, what is that?
Yeah, no, that's a good point. It's a good point. It does seem unfathomable to me why there was not an objection.
Well, when I was before I got hired by the PDs, I worked in appeals, and there was an appeal that I won. It was probably the biggest thing I ever did as attorney, quite frankly. I got a murder conviction overturned, and it was a little slight slip up on in the jury instructions where the judge left out a not. It was very clear the word not was left out, and it was really important. And it and there was an objection raised, and that was one of the nicest judges too. But the judge made a mistake, and if someone hadn't preserved that, then this guy would have still been sitting in jail. So you have to preserve, even if it's a nice judge or even if you know you're going to lose, you've got to preserve all those issues, because it's super important to just make sure that the appellate attorney can work for you, because sometimes the client may not have a chance in hell, but they might not appeal, even if they don't at trial level.
Yeah. All right. Well, the clock has run out on Stephanie joining this episode. So, Steve, I think you're going to have to do it on your own. Give us the entertainment and substance report from Las Vegas.
Well, yeah, the entertainment. I posted a bunch of pictures on Facebook just because it was quite striking. It did rival and may have even topped the Nelly concert at Filevine. I mean, the place was striking. I mean, the Dre's nightclub was something else. And Flo Rida came and performed, and then Flavor Flav showed up and performed, apparently unexpectedly, which was kind of cool, even though they're both not top name performers, I guess.
Flavor Flav is a top name. Public Enemy was a pretty big deal.
Yeah, I guess that's right. But so it was really a cool party. I'll have to hand it to him. It was a cool party. The conference, lots of good stuff. I mean, I sort of had a sense that a lot of the people were trying to find their way in the new AI world and how it was going to impact legal operations, and whether it was going to end up with C-suite people thinking, well, we can use AI for a lot of this stuff, but we don't have to have such a big role by legal ops, which I don't necessarily think is correct. But I kind of got the sense they talked a lot about human skills, which of course everybody that's got any concern about what generative AI may do to them and their jobs immediately talks about human skills, and there is a place for that. There's also a fair amount of talk about whether they could harness generative AI to do more things in the legal ops space and actually become more of a player as a result of that, and even try to expand what they do more into the business itself, because they do business things more than they do legal things, I guess. So there was a lot of that kind of discussion. I heard some talk that there weren't as many vendors as there have been in the past. I don't know that that's true. I heard some scuttlebutt about the attendance being down. It didn't seem to be down to me. I haven't been in a couple of years, but there are a lot of people there. But so I couldn't confirm either one of those things. But it was a good conference. I mean, there's some really good stuff. The keynote that I went to was a little wobbly, I guess is the best way to put it. There were good thoughts in there. It's just like the thoughts were all sort of not connected very well. We go from
Who was
here
the
to here to
keynote?
here to here, back to here, and then over here. And then let me tell you about, I mean, so anyway, it was a little less than what I expected, but I had a good time.
Who
And
was the keynote, Steve?
Nancy Rademacher, who holds her, and I was telling somebody about it, and it's a question of expectation. She holds herself out as an international keynote speaker, which I've never heard of as an occupation.
That's
But
her job.
if you're going to say you're an international keynote speaker and that's what you do for a living, you better be ready to wow everybody with what you provide.
Yeah.
Too bad Stephanie's not on. I'd be interested to hear her viewpoint on all of this.
Yeah, it is too bad because I wasn't there. I have actually still never been to a single CLOC conference. Every year there's like some reason I end up not going, and I'm always saying next year I'll go, and then I don't go.
Well, that's an interesting point, Bob, because it's each of these conferences has a little bit of a different audience, and this is a different audience. I mean, these are people that work on the business workflow process of what in-house legal does and tries to improve that and improve the workflow with outside counsel as well. So they have a sort of a little bit of a different mindset. It's a little more nuanced, focusing on business things. A lot of focus on, at least in the vendor hall, and I think in some of the sessions, on how to manage and corral outside counsel and those kinds of things, and on how to manage legal spend a little bit better. So it was a little different group. It's kind of refreshing to hear that viewpoint.
Yeah. All right. Well, your thoughts on CLOC? All right. Niki, why don't go to your story? I thought that there was an interesting, ethics opinion to talk about this week.
Yeah,
I'll
it
review
was an
that.
opinion out of Virginia. It's a proposed opinion. That is, one sec, let me get the link. That talked about billing, particularly, specifically alternative fee billing, and it talked about how the whether it's ethical, how it's ethical to charge for flat fee billing when you're using artificial intelligence. It's a proposed opinion, so it's still awaiting comments before it's finalized, but it raised some interesting points, and it also took issue with something from the ABA opinion. So basically and I thought this was a really interesting opinion. It was really, really well written, nuanced, and I also appreciated out the very start of it, the committee said that while we're talking about AI, this analysis can certainly apply to the use of other technologies as well. So I love it when I see ethics opinions ensuring that they're not narrowly focusing their holdings so that it will stand the test of time, or their conclusions. And then essentially what they said was that the time gained because of AI efficiencies doesn't automatically require lawyers to reduce their fees when they're using alternative fee billing. And that in addition to the legal work, the knowledge required to effectively evaluate and apply the AI tools has value. And they disagreed with the conclusion that the ABA reached in Formal Opinion 512, where the ABA suggested that it might be unreasonable under Rule 1.5 for lawyers to charge the same flat fee when using generative AI as they would have had they not used it, or before generative AI came along, for example. And instead they said that using the AI-driven productivity gains shouldn't effectively penalize lawyers and force them to reduce flat fees, which I think makes a lot of sense, and that they shouldn't have to forfeit a reasonable profit if clients continue to receive value. They did note, however, that Rule 1.5b requires you to adequately explain the cost of legal work, including value-based fees to clients. So that with AI, it may require you to provide a little bit of additional insight into why you have this, this fee, even though AI increased efficiency, so that they understand the value of the services and how you came up with that fee and why it provides, why it's worthwhile to them. So I thought it was interesting. Most of the other opinions have certainly touched upon this issue, but kind of in passing, which is sort of what happened in ABA's opinion, because they're addressing all the issues. There's so many issues that are triggered when lawyers use AI that we need to think about, and new ones come up all the time. Like, for example, one of the opinions had raised something we talked about on this show that had never occurred to me, which was conflict checking in larger firms where you have those ethic walls in place, and not conflict checking, but ensuring those ethic walls are not breached when the AI might serve up a response to someone else in the firm based upon the law firm's data for a case that they're not supposed to have any information on, because you've got those ethics walls in place where there's a potential conflict that was resolvable by putting those, I know they call them ethics walls. We used to call them Chinese walls, and
Chinese
now they've
wall, yeah.
changed the name. But ethics walls sounds weird to me. I feel like there's got to be a better name for it. But in any event, that was not something I'd ever thought of. And, so I think those issues are going to increasingly crop up, especially as these tools become embedded in the software that lawyers are already using that leverages the law firm data. But, for now, and I think we're going to see more and more opinions that delve into specific issues rather than addressing AI with like a broad brush, if you will. So I thought it was an interesting opinion, and I'm looking forward to seeing how it shows up in formal form.
Yeah, I thought this was an interesting opinion. I thought, to me, the most interesting part was I'm going to read the sentence out of the opinion. It says, the lawyer's judgment in determining when and how to deploy AI tools and the expertise needed to critically evaluate AI-generated content represent valuable services for which the lawyer reasonably can be compensated. I think, Niki, you mentioned this in your story, but it's basically they're saying, part of what you can charge for is understanding these tools and understanding how to apply these tools, which I don't know if I've ever seen that in an ethics opinion before. There's sort of an assumption that lawyers are supposed to understand the technology that they work with, but I've never seen an ethics opinion say you can charge for that time you're spending, I don't know, maybe deciding which AI tool to use in a case or how to craft prompts or something like that. It seems to be what they're saying there, and I thought that was interesting.
I was, and sort of along that same lines, Bob, I was listening to the Pioneers and Pathfinders podcast today. He was interviewing a trial lawyer who tried a case using a lot of the AI tools, and he was talking about just that, how he was able to evaluate the different tools, use them in conjunction with one another, and harness the power of the tools. And I was thinking that when I was hearing that, I was thinking that it's really a pretty valuable skill if you could, if you can use it, and you should be compensated for it. Thanks.
Yeah, but I've never seen nobody's ever said you should be able to charge for figuring out how to put pivot tables in a spreadsheet or something like that. I mean, it's
well, yeah. I mean, I don't think I wouldn't think it would be so much a charge for doing it as the value is perhaps reflected by your hourly rate.
Yeah.
And that was one of the panels I went to at CLOC. They were actually talking about that very thing, where what we could see in the future is hourly rates that go up, significantly up, because of the skills that are, the billing attorney now has that he or she didn't have before. That brings a lot more value to that hour than what did in the past.
Any other thoughts on that?
Well, did it specifically say that like it would I guess like the judgment skill requisite to perform the legal service properly or whatnot would include like all the pre work that goes into like the crafting the prompts and the training it and that kind of stuff. Did it specifically say that, or it was just kind of a general like kind of catch-all kind of thing?
Did the opinion say that? I'm not sure.
No, I was just curious because I mean, if it specifically said that, then that'd be pretty noteworthy, right? Because then it's like then so like what you're saying is like they're actually encouraging it seems like they really understand like what it takes to kind of craft an actual prompt, to use the technology properly as opposed to just sitting person in front of it and having them go. And so, it would seem like they've actually thought about the situation and understand that, there's a lot of pre-work that goes into it. It's not just sitting in front of ChatGPT and it's typing away and getting your answer immediately. Like there's work that goes into it beforehand, and then the lawyer should be compensated for that. That seems to be a pretty enlightened take for me.
Yeah. Yeah.
Well, and I talked about this last time about how I'd been on a panel, and one of the people on the panel was the chief innovation officer at Reed Smith, I think it was. And he had said that one of the things they're trying to do with AI is like really the faster turnaround. And that right now they're just assuming that provides value, but that seems to, and so they're working on the pricing as they go. But that's, I think, another value add that I don't think I saw mentioned in this opinion, but is the faster turnaround for clients, right? We were able to get to this a lot faster because we used AI, and that has value. That isn't necessarily, it's a different kind of value than you otherwise would have ever had before, because we never could have done it this quickly if AI hadn't been available to help us. So I think that's a value add too that should be compensated monetarily, right? That you can use as part of the discussion with a client when you're talking about the flat fee or the alternative fee billing, whatever it is you're doing.
Yeah. All right. Well, back to California, where the drama continues around the bar exam. Victor, you've got some updates.
Yeah, so it's kind of this is the California portion of our weekly show, I guess. So the funny thing is that like the whole point of this whole thing was to save money. Like they were hemorrhaging money, and understandably so. It's a very difficult undertaking to do this in California, a state like that where things are so spread out, and you know things are so expensive and everything like that. And so you have to rent out like these big arenas. You have to block off all these hotels. Um, you know, all this logistical nightmare for a state like California. So this whole point was to save money, that they would contract with Kaplan to create a test for them, so they wouldn't have to keep losing money on the MBE. So now it's like they have to go back to the MBE because the Kaplan test was such a disaster. They have to go back to the MBE. The Supreme Court ordered them to go back to the MBE for August. So they're gonna have to now go through all the problems that they had, that they'd hoped to avoid, and they're being sued for everything that's gone on. So this is gonna cost even more money now, probably, like most likely. Whereas like they probably could avoid this whole thing if they had maybe taken a little bit more time to ramp up to this, maybe run like some simulations and some tests so that they could make sure they got their technology correct, and that they could stress test it and everything like that in the field to make sure everything went well. But because they were in such a hurry to get this done, now it's going to end up costing them God knows how much more. So good job, California. Well done. And they lowered the bar score for everybody so now they have an artificially high pass rate. So
it's so bad. And like, so I've been writing about this for a while, and I wrote about this most recent move to go, the court ordering them to go back. I put a lot of blame on the California bar examiners for a lot of the reason they weren't able to test this properly and take the time is that they dilly-dallied until they were right up against bankruptcy to raise the issue. And then the stodgy powers that be in California were like, oh, I don't know, should we really change for far longer? And then they put themselves in a position where they had to pull the trigger way too fast. What bugs me about it is, and I've heard some people make certain complaints, and I will explain. I hold them with some grains of salt. My problem with going back to the MBE is most of the issues, which, the lawsuit is against Measure, who were the people that they hired to administer the test, who seemingly had no idea how to proctor a test based on what the allegations say and what I've heard from people. So at the point that they went back to in-person, which does bring back all those costs that they were trying to get out of, but at the point they went back there, then keep using the Kaplan test, because nobody's really complaining about the test itself. All the complaints are about the glitchy interfaces, the bad access to practices, the bad proctoring. At the point that they went back to in person, why do this? The Kaplan test, the only complaints that anybody really has about it is that issue, and I think we might have talked about it on here. I don't know, that I wrote about a week or so ago, where they disclosed that a handful of the questions were created with the assistance of AI, and everyone lost their damn minds because you bring up AI and bar exam, two subjects that people are known to be rational about, and then they just went absolutely insane. So put aside all of that. Like, I've heard some people say, oh, well, there was this confusing question, that confusing question. I don't think it was well written. And I hear that, but I also have covered bar exams for over a decade at this point, and I promise you, every MBE ends with me getting a million emails from students and examinees going, this question was busted, that question was busted. So I don't necessarily know as though that's unique to this process. I don't really have a reason to believe that the Kaplan part of it was bad, but by going back to the MBE, by forcing themselves to go to, and it's not just being all in person, but being all in person the way that the NCBE makes them do it, which is that very expensive giant arena way, it just throws out any attempt to fix this problem out wholesale without, for no good reason. And I fear it's going to set them back. One of the big issues, so I view the NCBE as a monopoly that is bad and needs to be broken up. They do all of this across the country. They're a nonprofit with $175 million in assets for some reason, and they force everybody to do this. And one of the key issues that's a complaint in this case that bugs me is some people are saying, oh, the Kaplan test was bad because it didn't have the right experts vetting it. But the reason they got rid of a lot of the experts in California who were supposed to vet it is that there was a implied threat from NCBE that since those experts had previously worked for vetting the NCBE's questions on the MBE, that and the California section of that they would potentially be an IP problem that they would sue over. So this monopoly power said you can't use those experts anymore. They didn't necessarily say that, but that was the intimation, which is why California then dropped those experts and got new ones. And now everybody's complaining, well, you didn't have the right experts. It's like it's a big ball of problems, and that all starts at Ma Bar. I'll use the Ma Bell analogy, and somebody needs to bust that up.
Corporate greed. It's like full circle from the beginning of
Yeah.
Web simulations. These are like two of my favorite topics, so I like this one.
But it's not like it's just, I mean, what is it? It's just the career for the rest of your life. That's no biggie, have a little forgiveness in your heart, Joe. Jeez.
I mean, just like there's so many other ways we could be licensing people. And, like during the pandemic, there was a lot of conversation about diploma privilege, which I think in the short term is not feasible, but I think in the long term is the way to go. I think that law schools, we need to have harsher accreditation, and law schools actually create practice ready people, and then you just get to go to practice. But put that aside, apprenticeship programs, I actually don't understand why an M&A lawyer has to understand all the rules of evidence from memory. Doesn't make much sense to me. Why don't we can have a generalist exam, and then we can have exams that are for, specialized areas. Like, there's so many different ways to do this if you just opened your mind and got rid of a monopoly that profits off of it.
And I don't necessarily agree, Joe, that we can't have a diploma privilege in the short run. I practiced in a state that had a diploma privilege, and I mean it seemed to work fine. I mean, it's just like, granted, you might have to say, okay, let's have a conversation about what are the basic skills and basic substantive knowledge you should have as a lawyer, and let's make sure that the law schools teach that. And if you pass the exam in those classes,
yeah,
that's it. I mean, that's all you need to. What do you need to do more?
Wisconsin does a great job with that.
Well, the whole premise is kind of flawed, right? Because the whole point of the bar exam is that then it's like you're presumed to be able to practice any kind of law. Like even if you're a criminal lawyer, then you could conceivably go work for an M&A firm or do real estate closings and whatnot. But look, in real life, you're never going to hire a lawyer like that. Like if you need to get your real estate closing done, you're not going to hire like some legal aid lawyer. No offense to legal aid lawyers. Just like you're not going to hire a DA, you're not going to hire an M&A partner from a big firm. You're going to hire someone who's qualified to do it and who's experienced. And also if you look at other trades like in medicine, like you're not presumed to be able to practice any type of medicine. I mean, could you imagine how crazy that would be? It's like, all right, well, you're a dermatologist now. I'm going to have you operate on this cancer patient. That's not how it works.
Well, I would.
I
Well,
guess, that.
in fairness, the dermatologists do a lot of cancer, but yes, I get your point.
Cardiology. Sorry.
I would disagree with the proposition that that's the whole point of the exam. It's a hazing ritual. I think that's the whole point
agree
of the
with that.
exam. And
Yeah,
all that other
that's-
stuff is just,
It's
made
just
up
bullshit. Yeah. And,
I'm-
I guess you could say, okay, well, if you're going to be a solo or in a small firm in a smaller area, maybe you need to have certain general skills, but you can't predict that at the beginning. I mean, so and the truth of the matter is that the bar exam really focuses on what you can memorize and was designed for a time where maybe memorizing that kind of BS was important because you couldn't access it. Everything you can access everything now. So what's the point? Why have it an exam? Why don't make
We
these
were just-
exam, open book if you're going to do this? So see if you can find this stuff.
Yeah.
We were just talking about this ethics opinion that puts value on having certain skills around technology. There's certain practice skills, business skills, all the things that actually go into practicing law. None of that is tested on the bar exam.
Yeah.
Well, and that's
As everybody's already
it's
said,
ridiculous.
it's just rote memorization, and that's all it is.
Well, and I think, Steve, that's a really good point about how, and that's what occurred to me when somebody was talking. I can't remember who it was, but Joe, people often end up practicing a very different type of law than what they thought they were going to practice. And I don't think that we want to put ourselves in the same lane as doctors in that way, because what happens with physicians is, and my brother's a great example, he almost had to switch halfway through residency because he got Kunkunyanga. I can't remember exactly how to say it. It's like a tropical virus that caused him to get rheumatoid arthritis in his hands, and he was in a surgical residency.
Wow.
And he almost had to, if it hadn't resolved itself, he wouldn't have been able to do surgery, and he almost had to switch to radiology, and that would have added like 4 more years onto his path. And so it's really, really hard once you accept a residency to change your career path in medicine. And so, and I think it's much easier in law to you switch from one firm to the next, and all of a sudden you're in a different practice area. You go solo, and suddenly you're a generalist, right? So I think that there's got to be some in between where the exam covers a lot of the specifics, and then if you think you're going to do something, maybe there's an in between apprenticeship or something, but it doesn't necessarily preclude you and get you so far into it that you can't go backwards and go into something else.
I think an introductory sort of exam, and I think obviously the ethics part of it's going to be that, right? Like, is something that's like, hey, can you not be an awful person in this job? Understand the basic responsibilities probably does need to happen. And then I would love that if once you pass that, there'd also be exams for specialization. But if you change your specialization, if you passed the general part, then you can wave in with some sort of a time served under somebody who's an expert. Just like when you start talking about it, there's so many creative ways to build a licensing system that is better at what it's supposed to do. First of all, avoids a lot of these problems. Like we could do so much, and no one does that because one organization makes a lot of money saying that it has to be one way.
What was that?
Yeah, and
film
I
just
would, now that
saw?
you said that, Joe, I think I would support at a bar exam that focused on your ethical obligations as a lawyer. That does make some sense. Because I mean, that is something that every lawyer should know enough about to be able to not screw over his clients.
Is there a Zoom feature that I'm unaware? I thought I just saw like a thumb floating in front of your face, Joe. What was
Yeah.
that?
Yeah, no, if you have like a new enough computer, it does that. I can't remember all of the. Yeah, there it is. Yeah, I can't remember all of them, but if you do certain things, it does that. I think
Nick,
this
Nikki,
causes like.
don't hold Don't
Yeah,
hold
there we
your
go.
middle finger. Nikki, don't hold
Oh,
your
so did
middle
you hold
finger
your
up.
thumb
That's
up
not a good
though? Is
idea.
that what happened?
Yeah, you hold your thumb up, it'll do it. It'll do that. My doing
Oh,
these causes confetti to fall. Yeah,
well, it must have been you just held your thumb up while you were speaking and then that happened.
yeah,
And
yeah.
then I
Hey,
got it.
Joe,
Okay.
what
Sorry, that
happens if you
confused me.
hold up your middle finger?
I I'm sure something.
Try it.
Sorry, Nikki.
That's okay. I just got so like I'm like, am I hallucinating? Am I getting a migraine and I don't know what's going on? I mean, what
Hilarious.
was that?
It's all part
Amazing.
of the simulation. We're being watched. We're being watched. They're like putting little thumbs up on us all the time. All right, I'm gonna. We won't fix the bar exam today or the bar licensing, but to be continued, I'm sure. Um, I had a story this week. It's a little bit of I think a little drama in the legal research world is the way I'd put it, because I did an update today that I published, but it was on a story I first wrote about a couple of years ago, where uh, Relax, is that how they say it? Relics, RELX, which is the parent company of LexisNexis, sort of quietly in 2021 launched a legal research service called Decisis that nobody marketed or put out any PR about or anything else. It just kind of appeared. And it appeared that what it was doing was going after the Bar Association member benefit business that Fastcase had kind of wrapped up. And if you remember, 2021, 2022 is when, for years, there had been Fastcase and Casemaker had been competing for this business. Then Fastcase acquired Casemaker, and then suddenly, in late 2021, Fastcase basically owned this business all across the country. And basically every bar association member benefit program was with Fastcase. I mean, kind of like well, I won't say what I was going to say, but so this crisis showed up, and they kind of when I first wrote about them, I couldn't even find anybody to talk to about them actually, and it was a little bit mysterious. But then a little while later, I was able to kind of connect with Jeff Pfeiffer, because it turned out, Jeff is, we all know, like the sort of the international head of product or whatever he is at LexisNexis. I mean, he's a guy we've all talked to a million times, but he's also like the founding president of this other subsidiary corporation. And he confirmed that, yeah, we've just kind of started this to go after this bar business. And it's a very bare bones legal research service. It has a citator, and it does the job. It's not LexisNexis. It's not powered by LexisNexis. It's a freestanding legal research service, although they're data from LexisNexis. But anyway, that was 2022, at which point they had 2 bars that had signed up for them. So I decided to check back with them, and they've been adding bars at a pretty fast clip. Just in the last year, they've added 10 more bars, so they're now up to 20 bar partnerships across the country, and 14 of those are actually state bar associations. And in fact, 2 of them haven't even announced on their own websites yet that they're moving from Fastcase to Decisis. If you go to their website, they still say Fastcase as a member benefit on it, but they're moving within the next month or so once everything gets set up. And it's what part of what's interesting is it's a very bare bones research service. There's no AI, and they're very clear about the idea that we're not going to have AI. If people want AI, then they can subscribe to LexisNexis or something else. So I kind of I talked to Ed Walters at Fastcase and got his take on it, and he sort of, well, we welcome the competition, and competition's a good thing, but he said, but they're giving their, basically saying the bar associations are giving their customers a half-baked product, whereas with Fastcase VLEX, bar association members who subscribe to their product are getting the same product that lawyers and big firms who subscribe to VLEX are getting, or anybody else who's getting VLEX, including AI features. So that is sort of an interesting question, I think. I was a little bit surprised actually also by some of the feedback from some of the bars on Fastcase. Some of them really didn't like it, weren't happy with it. There was a one got the minutes of one bar association meeting from fairly recently where the executive director reported to the bar's board that she was really surprised at how much some of our members dislike Fastcase. So there's some dissatisfaction there. But I guess the whole thing, the whole story, other than having some drama to it, kind of raised this question in my mind of how much do all these AI features in legal research that we've been talking about really matter? I mean, for the day-to-day research that a lot of lawyers would turn to a bar association member benefit research service for, do they need any of that stuff? Do they need any of those bells and whistles, or is it okay to just have your good old-fashioned Boolean search legal research kind of platform? And I don't know the answer to that, but you know, for all of the time, for all of the focus over the last 2 years on AI-driven legal research, I still wonder how many lawyers are actually using those tools, and or put it more strongly, depending on those tools, or whether they're still kind of doing research the way I always have.
Well,
So
where I've seen, I think
It's, a,
I
it's an
don't,
interesting point, Bob, because I know Kentucky switched to Decisis maybe a couple of years ago. And the comments that were out there were along the lines that you mentioned, there's sort of dissatisfaction with Fastcase for whatever reason. And then when it became VLEX, I think, you know, sort of the impression by many lawyers, rightfully, well, wrongfully probably, was that Fastcase was, you know, going to be focused more on international and wasn't going to focus on the state bar and all that. But point I was going to get to is in the process of all that, the Bar Association looked at usage of Fastcase, and even, you know, any usage whatsoever was very small, which sort of, I guess, kind of supports your point that many lawyers don't care about automated research at all, and the ones that do certainly don't need as many bells and whistles as there might be, and maybe it even complicates their ability to use it.
well, that's most of the small firm lawyers that I've talked to tend to be more interested in drafting capabilities. And I've had quite a few people reach out to me lately asking me if I knew of any tools that would allow them to query their firm's database, because that isn't something that's widely available in any accurate form right now across other legal tools. So I think that you know, I think with research, they just want to be able to do basic research, and it's only certain practice areas that even need that. Like I absolutely needed it as a civil litigator, but when I was doing criminal defense, you didn't need that as often, because often the motions and stuff that you filed were kind of rote, and it was pretty unusual, unless you were doing appellate work, that you really needed to do a ton of research. Although you occasionally did. Also, I was a public defender, so keep that in mind. I had 600 cases, so I wasn't doing a lot of research on any case. But I do think that but when you talk about larger firms and also corporate counsel, which, by the way, all the data showing they're using it the least and they're the most cautious, I think they can benefit from it the most. Like those 50-state surveys, which are so valuable for like a corporate counsel, and it costs so much money for them to outsource that and then have a outside firm constantly update that information as like the laws change in different jurisdictions. And like I've seen it done in VLEX, and I know the other ones can do this. It can do it in a heartbeat and automatically update that as you go. That saves them so much money that, you know, there are certain situations where these legal research tools and additional functionalities that they have can be incredibly useful. But I think it scales more the larger a firm gets, and unless you're a unique sort of boutique litigation firm that's a small firm, it may not be as valuable to you. Class actions, I can see where it might be more valuable than just standards, you know, insurance defense litigation or something. But it is interesting to see how different, and that was one thing we looked at in the industry report, is how we're different size firms. We're parsing the data across different things, but how are different size firms using software in general, including AI? And it's interesting to see that, and how it changes across practice areas too.
yeah. Noticing in the chat, Rebecca talking about the fact that although Decisis Citator says its Citator is completely separate from Shepard's, she's saying that from what she's seen, the signals line up pretty much exactly, which suggests there is some relationship there. And it's funny, this whole thing about how they are distancing themselves from LexisNexis, saying we're not part of LexisNexis. But the guy who runs it now is a LexisNexis employee. He's not a Decisis employee. Everything about it points to LexisNexis. The development team, as far as I can tell, was mostly with LexisNexis. So I don't know why they're going through this dance to try and distance themselves from LexisNexis, other than so there won't be, I think because they don't want. I think they don't want people judging LexisNexis by the Decisis product or something. I don't know.
I wonder what the business play is. That's what confuses me about it. I mean, is it just since it sounds like there's not a super high use case, I mean, this is anecdotal from what I think you said, Steve, but of Fastcase across the bars, even though it's available, is it, and since they're not branding it as Lexis and they're really distancing themselves from it, it doesn't sound like it's a entry-level LexisNexis, if you will, where they can reach out and sell you higher levels or more, more expensive tiers of LexisNexis. They're distancing themselves from it. So is it just a play to knock Fastcase recognition out now that but this happened before they were acquired by VLX. So, and they can't make that much money, I mean, compared to what they make from LexisNexis in terms of their individual contracts with the bars. So I wonder what the underlying business play on this is. And there must be some value piece that we're missing or I'm missing. And I'll have to think about it a bit.
Yeah, I think I don't know that there is any substantial business to it. I don't think they're charging a whole lot of money for it, because all the bars seem to be saying financially it's a no-brainer compared to getting Fastcase. But the guy that I talked to who runs the Decisive service did say that they are, as part of this relationship, also offering to the bars to do a lot of training for them on AI for legal research and how to use AI in a law practice. And so they're definitely using this a little bit as a loss leader, in a sense, to kind of upsell or try and create some avenues to upsell into LexisNexis. But still, it's a pretty complicated way to go about trying to do that. You don't need to start a whole other product to do that. So, and I'm sure part of it is just anti-competitive. I don't know if anti-competitive, I don't want to say it that way, not in a legal sense, but I mean, they're just trying to push Fastcase out.
But yeah, I mean, you got to go back to corporate greed. There is a business purpose for this. They're not just doing it for the good of their hearts. And if they were, then they would absolutely brand it with LexisNexis and make it seem like it's a pro se type of, this generous thing that LexisNexis is doing for lawyers. The fact that they're distancing themselves from it is interesting. And maybe it is going to be that cross sell or upsell opportunity as the AI tools get even more embedded in what we do. And I wonder if that's it, but there's got to be something. But this came about before generative AI, right, Bob? Didn't you say it was a couple of years before? So I think
yeah, well, yeah, 2021 is when it launched, late 2021, right? Its first customer was like November of 2021.
Yeah, so that's really interesting. It's worth
I
thinking.
know when they approached the Kentucky bar, they were upfront that they were affiliated with LexisNexis, but they never identified that as a particular benefit, other than, you would be access to the LexisNexis database that would pull from. And actually, now that I think about it, I'm not even sure they did that. I mean, it was more like, yeah, well, we're sort of part of LexisNexis, but here's what we're doing, kind of thing. And it wasn't. I never got the sense, and I talked to them a couple of times. I never got the sense that they were trying to use that LexisNexis use what they were doing as a tool to get people to sign up for LexisNexis. They certainly didn't make that obvious to me.
Yeah. No, they don't even make obvious their connection to LexisNexis, really. They're not
Yeah.
all that explicit about it. It's really funny. But all right, well, we are at the end of the hour here. So we'll have to leave solving the problems of the bar exam and AI ethics and everything else till next week. And anything else? Any closing thoughts before we wrap up? Good. All right. Well, thanks to everybody for joining us today. And thanks to all the panelists for joining and sharing their thoughts. See you next time.
Have a good weekend.
Well.